Very often, we come across deeds, grant deeds, or quitclaim deeds that are poorly drawn, making us wince or frown or making us raise our eyebrows. These forms might have been drawn by all sorts of people, escrow professionals, attorneys, or the general public. And most of the time, we are surprised that there have been no repercussions. This is Juliana too, and this is a follow-up to my short video regarding the differences between the grant deed and the quitclaim deed forms. Be sure you check out other links on this topic in the description below. But before we start, let me go ahead and give you our disclaimer. The information contained in this video is only intended to provide a guide in the various California-only transactions to which the information is applicable. No representation is made to the legal validity of the information or the adequacy of it in any specific transaction. The information contained should only be used after consultation with your legal and financial counsel. When I talk about a deed here, it could be either a grant deed, which transfers the property with specific warranties and guarantees, or it could be a quitclaim deed, which transfers no guarantees. These two forms that give the different types of warranties to the person receiving the property are described in my separate video on that topic, link which is below in the description. Our discussion today is what makes a deed a good one, a voidable one, or totally void piece of document. Now, for a deed to be good, there has to be 6 components. First, it must contain the names of the persons, the grantor, and the name of the person receiving it, the grantee. Secondly, it must state in the document the action that you are doing, the granting or the quitclaiming it. It also must have the correct legal description or the correct property address described in the document. The grantor and the grantee have to be both of sound and capable mind. And also, as you know, the document has to be signed. Finally, the document has to be delivered, and this is important, it has to be delivered to the person, and that person must accept this transfer of ownership. Now, you might have thought that for a deed to be good, it has to be notarized or it has to be recorded. No, not true. Signed, delivered, and accepted are good enough. However, if you wanted to make it a public record so that anyone who looks up the property can see who is the owner, then it can be recorded at the county recorder's office. Then there would be no mistakes as to the ownership. Also, if you are going to have it recorded, then according to law, you have to have the document notarized. So to make it the deed good and whole, the 6 requirements that I mentioned, plus 2 more, notarized and recorded, must be in place. So what are bad or voidable deeds? When some of those 6 requirements are missing, it could be a voidable deed. And there's some other instances which it could be voidable. First of all, a deed that is originated by fraud. For instance, when a fraudster promises to get a loan modification done if the property is signed over to him. Or if a deed was originated through a mistake. For instance, when the deed has the wrong property address or the legal description. A deed that was signed under duress or under threat. This is also a voidable deed. A deed that is given by a person who may be mentally incompetent, meaning it's not fully determined by the courts, but there's a mental capacity issue that we are all aware of. By the way, on mental capacity as an escrow agent or a notary public, when a person signs a document in front of you, it is important that we verify if the person is mentally capable. And if there is any question, we should not allow them to sign. A deed that was altered without the grantor's knowledge or consent after it was signed is also a voidable deed. Now, the ugly. The ugly is the void deed. And these are deeds that are void no matter what. When that deed is forged, or a deed that was signed by a person who completely does not understand the language, or a deed that was signed by a person who is determined to be mentally incompetent by the courts. A deed that was signed by a minor is also void. A minor is someone who is under 18 years of age. An escrow officer or a notary will need to verify that this grantor is of legal age before they sign. And they can do this by looking at the photo ID carefully. A deed that was signed without the grantee's name in there and later added on without the authorization or the consent of the grantor. The laws for notarizations, by the way, state that notary publics are not allowed to notarize documents that are incomplete or have obvious blanks in them. A deed that is signed to a fictitious business name. For instance, grantee is John Doe Plumbing Service. This is a DBA for John Doe. It's not John Doe himself. It's his plumbing service he's doing business as. So it needs to be a deed to John Doe himself and not to his plumbing service. You also cannot sign a deed to a person who does not exist. For instance, like Frodo in the Lord of the Rings, or a non-person like a pet. So what happens when a deed is void or voidable? The first thing you need to do is review the document. Determine, why are you concerned? What has happened that makes you concerned? You should also talk to the person who prepared the document. What happened there? And if you can't figure out what happened, then talk to an attorney. Because either the grantor or the grantee could be harmed by the consequences of such a deed. So let an attorney review the background and give you counsel. Here are some industry stories, examples of the most common issues that we have actually seen. The most common one is a mistake in typing the wrong address or the wrong legal description, which ends up the buyer not owning the right property. Fraud is the next common issue that we see. And the most common fraud is one that's perpetuated by a family member. We had a case in which the son was trying to sell the father's property. They both had the same name. And you just couldn't tell just by looking at the driver's license that it was the son and not the father. However, we realized that the real owner had owned the property a long time. And the age of the son then, from the driver's license, did not match the ownership records. Another type of fraud is one in which a fraudster uses identity theft and does a fake ID and sells the property. Usually it is a property that has, one, no loan on it, and two, the owner does not live on it and it is empty. One more story of a fraud that I happen to hear of is a deed that was actually stolen from the escrow agent's file and then recorded before the transaction finalized. A deed was signed and recorded without a grantee being aware of it. and the grantee was not given the chance to reject the ownership of the property. He became the owner of a property that had tax delinquencies and mortgage delinquencies on it. So this is a deed that is a bad and an ugly. A deed that was signed in escrow to buyer A, and then it was changed to buyer B without the seller's knowledge. The seller found out after the closing and proceeded to file a lawsuit that this was an altered deed signed without his consent, and so the deed was void and the transaction should be invalidated. A deed from a person who had no idea that she was signing her property away. This was done by a family member who would later on sell the property from under her. When it comes to documents that change the ownership, like a grant deed or a quitclaim deed, or even a deed of trust, which puts the loan on a property, the escrow agent has to be sure that they can trust the notary who is doing the signing if the signing is not done in the escrow office. These notaries then become our eyes and ears to make sure that all is well with the person who is signing. These are all industry stories, true industry stories of the bad and the ugly. Hopefully, I have answered some questions for you. I will be doing another question and answer piece in the future. Subscribe to my channel so that you will get upcoming videos that I will be posting. My t-shirt of today is Wicked. This is from the theatrical musical based on the Wicked Witch of the West, which is part of the Wonderful Wizard of Oz book. It is a great show, and I hope that one day they will convert it to a movie presentation. This is Juliana too. Thank you for watching. Again, check out the links in my description below, and please like me or subscribe me. Learn about those different things that can go right or wrong in the ownership of property. I shall see you in the next video. Thank you for watching.